My name is Nick. I'm an 11th year lawyer, and in this video, I'm going to face off against ChatGPT on the bar exam. We're going to be taking 5 practice questions and see who will win, man or machine. Stay tuned to find out. ChatGPT has taken the internet by storm. The chatbot was created by Elon Musk-founded company OpenAI. When OpenAI released it to the public around a month ago, more than 1 million people signed up for it in the first week alone. The artificial intelligence engine behind ChatGPT has been making headlines because of its capabilities, which are truly mind-blowing. For example, ChatGPT can solve complex math problems, write poems about any topic you can imagine, write scripts for TV shows, and even write computer code. But can ChatGPT pass the bar exam? In this video, we're going to find out. Taking and passing the bar exam is a rite of passage for anyone who wants to practice law and become a licensed attorney in the United States. To even sit for the bar exam, you must have 7 years of schooling after graduating from high school, including 3 years of grueling law school. Most test takers even spend several months leading up to the bar exam taking full-time bar preparation courses like Kaplan and Barbary. Despite all of this preparation, nearly 1 in 5 test takers fail the bar exam on their first try. I passed the bar exam on my first try, fortunately, but I will say it was the biggest academic challenge requiring the most effort and study that I had ever done at that point in my life. So with all of that said, let's get into our practice exam here. I will share my screen with you so that you can see exactly what I am doing. Now we're on barprephero.com's website and we're about to take this MBE practice test. We're going to answer the first 5 questions. The MBE, by way of background, is the multi-state bar exam. This appears in nearly, if not all, every state's bar exam, and it's worth about 50% of the overall bar exam grade. So now that you know a little bit about the MBE, let's move on to the first question. It says, a homeowner buys a new leaf blower and is so impressed with its power that he gets carried away and blows large amounts of his work onto the next door neighbor's yard. In addition to leaves, he also blew large amounts of pest-infested plant debris onto neighbor's property. Uh-oh, that's not good. The material has accumulated into large, unsightly piles and caused damage to the neighbor's healthy plants. He has to pay workers to haul the material away, and he incurs expenses to replace infected perennials. The neighbor sues for the tort of trespass. The homeowner files a motion to dismiss because the neighbor cannot prove that homeowner acted with an intent to trespass or to do harm. Will the court grant the motion to dismiss? Well, my first instinct without reading the answer choices is that the tort of trespass does not, I don't believe, require an intent to do harm. It simply means, or even an intent to trespass onto somebody's land. I don't believe that there's an intent requirement. Let's read the answer choices. No, because the infected debris constituted an abnormally dangerous condition and homeowner could be held strictly liable for trespass. That is not the right answer because it is not an abnormally dangerous condition to have plant debris. I don't think anybody would consider that an abnormally dangerous condition. It says no, because trespass is based on an intentional act of entering the land or sending something onto the land, and the actor does not have to intend harm to be liable for the tort. I believe that's a correct answer, and that's somewhat what I just said, but let's read the other 2 answer choices just to be safe. Yes, because the homeowner had no practical way of controlling where the material went, and he acted without malice or ill will. Again, malice or ill will, those are not 2 requirements of the tort of trespass. You simply have to intend to enter the land. Final choice says yes, because the homeowner expected the wind to carry the debris away and did not think it would accumulate on the neighbor's property. That is not even close to being the right answer. So we will go with no, because trespass is based on an intentional act of entering the land. And as you see there, we got that one correct. Now let's see if ChatGPT can get it right. So I will copy this question. Okay, now you can see ChatGPT. We are just going to go ahead and copy and paste that question into the chat field, and there it goes. It says, it is possible that the court could grant the homeowner's motion to dismiss if the neighbor cannot prove that the homeowner acted with an intent to commit a trespass or to cause harm. Trespass is typically defined as an unlawful interference with the possession of property, and it requires an intentional or reckless act. In this case, the homeowner's actions in using the leaf blower to blow debris onto the neighbor's property would need to be shown to have been intentional or reckless in order to establish a claim for trespass. However, even if the court were to grant the motion to dismiss on the claim of trespass, the neighbor may still have other legal remedies available, such as a claim for negligence. Negligence is a failure to exercise a level of care that a reasonable person would exercise in similar circumstances, and it does not require proof of intent. If the neighbor can show that the homeowner breached a duty of care owed to the neighbor by failing to use unreasonable care in using the leaf blower, then the neighbor may be able to recover damages on a theory of negligence. So right here, chatbot unfortunately got this question wrong. I will say this is a fairly accurate summary of the law, however, but it came to the wrong conclusion in applying the law to the facts of the case. This is a good starting point for analyzing the issue and identifying the issues in the fact pattern, but it ultimately got that question wrong, came to the wrong conclusion. So unfortunately, the ChatGPT missed question number one. That's score 1 for Team Real Lawyer and 0 for ChatGPT. Let's move on to our second question. This question says, a business person sent his employee an administrative assistant to represent him at a conference where business deals are often negotiated. The principal gave the assistant all of the materials to set up a table with the principal's cards, brochures, promotional materials, price lists, and even some order forms with business person's logo on them. In addition, the assistant represented to third parties that she was there officially representing the principal and that she was authorized to execute contracts on his behalf. So clearly, this is an employee agent of the principal business person there to represent the company and the business person. The assistant negotiated a deal, and I'm guessing something goes wrong here in about 2 seconds. The assistant negotiated a deal for the business person with a third party, which the business person refused to honor because he did not like the terms that were negotiated. Well, you should not have entrusted that task to your subordinate employee if you didn't value their judgment in negotiating contracts. That sounds like it's on you, business person. Shame on you for not honoring the contract and the terms of the deal that your employee agent negotiated. In any case, it says, will the third party likely prevail in enforcing the contract against the business person? This is probably a softball question. It seems almost too easy to be real. In my recollection, the bar exam questions were a lot harder than this one, but let's go ahead and see if I can actually get it right. Answer choice number 1 says yes, because the furnishing of the indicia of authority to act to the employee was sufficient proof to bind the principal. I would say that is probably the right answer. Let's see the next choice. Yes, because the principal is bound to the employee's actions whenever he sends an employee to attend a convention on his behalf. That is a red herring answer because although it's correct in saying, yes, the ultimate contract is enforceable, the reason that sending an employee to a convention on their behalf, that is not a legal element. That is not the sole requirement there to bind the principal. It requires something more than just sending somebody to a conference or a convention. It requires facts, as we have here, showing indicia of authority to act to the employee. And so let's see, the other 2 answer choices, no, because people dealing with an assistant at a convention have a duty to determine whether that person is in fact an authorized agent. That's not true. No, because of technological revolution, blah, 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 blah. Those are obviously not right. So we will go with this first answer choice, yes, because the furnishing of indicia of authority, it sounds legal, and of course it's the correct answer. Now let's see if ChatGPT can get this one right. Okay, so here we have ChatGPT. We are going to paste that question into the text box and see what it says. Chatbot GPT says it is possible that the third party may be able to enforce the contract against the business person if the assistant had actual authority to enter into the contract on the business person's behalf. Actual authority is the actual power or authority that has been given to an agent to act on behalf of the principal and bind the principal to contracts entered into on the principal's behalf. There are several factors that may be considered in determining whether the assistant had actual authority to enter into the contract on the business person's behalf, including number one, the principal's instructions or permission to the assistant to enter into the contract. Number two, the custom and practice of the industry or business. Number three, the representation made by the assistant to the third party regarding her authority to enter into the contract. Number four, the materials or resources provided to the assistant by the principal, such as business cards, promotional materials, and order forms with the principal's logo on them. If the third party can show that the assistant had actual authority to enter into the contract on the business person's behalf, then the business person may be bound by the terms of the contract. However, if the assistant did not have actual authority, then the third party may not be able to enforce contract against the business person. Well, unfortunately, ChatGPT, you got this one wrong as well. It is giving a very hedge type of answer here. It's not even answering a yes or no, which the question required. Granted, in fairness, ChatGPT does not have the multiple choice options that are available to me, so it can't select one out of the four options. But this is not really even the correct analysis of the law or the question. And unfortunately, ChatGPT, you got our question number two wrong. That is score 2 points for team Real Lawyer, 0 for ChatGPT. Let's see if it can turn things around on question number three. Okay, so moving on to question number three. It says two cousins took title to real estate as joint tenants with the right of survivorship. The first cousin put up his interest in the joint tenancy as security for a $20,000 loan and signed a judgment note. It was later entered as a judgment against the first cousin's interest in the real estate. The first cousin died a year later. The second cousin decided to sell the property, but the mortgage filed an action to prevent the sale and to enforce his interest in the property. The second cousin defended on the basis that any lien on the first cousin's interest in the property was extinguished on the first cousin's death. Will the court enforce the lien of the mortgage against the sale of property by the surviving second cousin? Well, full disclaimer, I am not a real estate lawyer here, and this is totally out of my realm. I don't really remember my property class over 10 years ago that I took, but let's try to figure out the correct answer by process of elimination here. Let's go with the first one and see. Oh, we got that totally wrong. So the correct answer was no, because when the first cousin died, the second cousin became the sole owner due to the right of survivorship as per the joint tenancy, which was still fully intact. Let's see how ChatGPT will do on it. So copy and paste question number three into ChatGPT, and let's see how it does. It says, it is likely that the court would enforce the lien of the mortgagee. Okay, so it got it wrong, just like I did. I also said the court would enforce the lien. Let's see what its reasoning is here and how it's arriving at that conclusion. So it's saying it is likely the court would enforce the lien of the mortgagee against the sale of the property by the surviving second cousin. Joint tenancy with the right of survivorship is a form of co-ownership in which each co-owner has an undivided interest in the property and the right to possession of the whole property. Upon the death of one joint tenant, the surviving joint tenants automatically become the owners of the deceased joint tenant's interest in the property by right of survivorship. I would agree with all that. That's what I thought. However, this right of survivorship does not extend to any liens or encumbrances on the deceased joint tenant's interest in the property. In this case, the first cousin's interest in the joint tenancy was used as security for a loan, and a judgment was entered against the first cousin's interest. The judgment lien would not be extinguished by the first cousin's death, and the mortgagee would have the right to enforce the lien against the sale of the property by the surviving second cousin. Well, even though this is not what the bar exam prep question had as the answer, this is still a really impressive answer by the chatbot because it analyzed it and came to the same conclusion that I did. It analyzed and thought through the question in exactly the same way that I did, with my 7 years of schooling, 3 years of law school, and all of my legal training, my 10 years of experience practicing law. So it's fair to say that this chat GPT is thinking like a lawyer, which is astonishing, quite frankly. And I think it correctly issue spotted the issue in this question, and I think it correctly analyzed it. And who knows, if I were to go and actually research Texas case law on this question, perhaps both myself and ChatGPT got this one right, according to the law in my state, which could vary from the law on the test that was, I believe, Illinois law. So, anyways, even though ChatGPT got this one wrong, I am truly impressed by its ability to summarize the law in a concise manner and also issue spot the issues and address the facts. So let's move on to our fourth question here. It involves constitutional law. That's always exciting. The state constitution in one state guaranteed the right to marry to same-sex and opposite-sex couples alike. A political group got a proposition on the ballot, and a majority of the people voted to eliminate the right of same-sex couples to marry. That sounds like Texas. The proposition did not affect any of the other rights that same-sex couples may have possessed from existing state law. Persons affected sued the state government for unconstitutionally taking away the rights that they had and doing it for no legitimate purpose. No legitimate purpose is not a constitutional or a legal argument, so this seems like a red herring fact. In violation of the Due Process Clause of the 14th Amendment, will the court grant the requests of the lawsuit and declare the proposition void and reinstate the rights of same-sex couples to marry? Our first answer choice is yes. Under the Due Process Clause, no compelling state interest justifies denying same-sex couples the fundamental right to marry. Second option, so I don't believe that's the correct answer. Yes, because under the Fourth Amendment, this is the 14th Amendment, but this is under the Fourth Amendment, it would be an illegal interference against the right of privacy guaranteed to everyone. That is not correct. This has nothing to do with the Fourth Amendment right to privacy. So the answer choice, I believe, is no. Let's see which of these two has the correct reasoning. No, because the people voted to take a provision out of the existing Constitution, and when that is done by public vote, it cannot be altered. Well, that's not true. If it's unconstitutional, it can be altered. So, and the Supreme Court does this all the time, strikes down unconstitutional laws that were voted on by the people. And so that is the separation of powers. That's how it works. So we know this answer choice isn't right. That leaves us with only one answer choice left. No, because the ballot proposition was properly placed on the ballot and all statutory procedures were followed, thus precluding the courts from taking adverse action. That also seems incorrect. So we've got four answer choices, none of which sound correct. The only one that I think, in looking back at this now using process of elimination, it looks like this first one might be correct because it's really the only one dealing with due process. The others don't even address due process. I'm going to guess that it's this first one, just using process of elimination and logic. Let's see if it's right. I got it right. I guessed correctly. Well, that's interesting. And that's certainly a controversial question. And right here, we see there is some case law on this topic, a 2015 case, Obergefell versus Hodges. So this is a good explanation of why that first answer choice is correct, although, it was an educated guess. So let's now copy and paste this and see how ChatGPT will answer this question. So here we have our fourth question. I'm going to paste it into the box here and let's see what ChatGPT has to say. It says, it is possible that the court could find the proposition unconstitutional and declare it void. Okay, so this is the first one that it answered correctly, came to the correct conclusion. So let's see its reasoning behind that. Thereby restoring the right of same-sex couples to marry. The 14th Amendment to the U.S. Constitution protects individuals from being deprived of their fundamental rights by the government without due process of law. If a law or action of the government infringes upon a fundamental right, such as the right to marry, then it must be justified by a compelling state interest and must be narrowly tailored to achieve that interest. Okay, that is an accurate, 100% accurate summary of that area of law, the due process law under 14th Amendment. So very impressive answer. It got the correct answer and it got the correct reasoning for that answer. So this is a major win for ChatGPT. It got this one right. It goes on to say, in this case, if the court determines that the right to marry is a fundamental right, then the proposition would need to be justified by a compelling state interest and narrowly tailored to achieve that interest. If the court finds that the proposition was not justified by a compelling state interest or was not narrowly tailored to achieve a legitimate state interest, then it may declare the proposition void and restore the right of same-sex couples to marry. So there you have it. That is impressive. Score one for Team ChatGPT. Score one for Team Real Lawyer as well on that one. So by my count, it is 3-1. And that means I win over ChatGPT. But let's go ahead for the sake of science and learning and do our final fifth question and see if ChatGPT can close the margin and get one more correct. Okay, so here we go. Let's move on to our final fifth question. It says it involves torts, MRIs. I better get this right. It says a patient who had surgery to repair a rupture in her spleen followed up with a full body MRI due to excruciating pain that had developed. During the MRI, the technician saw at least two identifiable sponges that had been left in her body. Oh, that's not good. She had to be hospitalized for additional surgery. The patient sued the hospital and doctor for medical malpractice. She did not produce the printouts of the MRI. Instead, she attempted to testify to what she observed on the MRI scan. The defense objected and insisted that she must produce the actual MRI printouts. What is the most likely ruling of the trial judge with respect to the objection? Objection sustained. Best evidence rule. The MRI scans need to be offered into evidence, not somebody's testimony. A layperson certainly's testimony about what she saw on those scans. That is not admissible. But let's see what our answer choices are and see if I'm correct here. But I'm pretty confident that that is the right answer. So let's go down to our answer choices here and see. First choice says she does not have to produce the MRI scan because a layperson can testify to things of common knowledge, such as what a sponge looks like. That is just quite frankly, a stupid answer choice. So we know it's not question number one or answer number one. Answer choice number two says she does have to produce the MRI scan because a layperson cannot testify to personal observations. So that is the correct conclusion, but for the wrong reason. So she does have to produce the MRI scan. I already said that. But a layperson can testify to personal observation. In fact, that's really the only thing a layperson can testify to. They cannot give expert opinions because they're not an expert, but they can testify to what they saw or felt or smelled or heard. And so that's not the correct answer choice either. Moving on to the third answer choice, it says she does not have to produce the MRI scan because she can testify as to the content of her own medical records. Now, that's a red herring answer. It's not right. She can't testify to her own medical records if she can produce those medical records instead. So that has to leave us with our final answer choice. She must produce the MRI records because it represents best evidence under the best evidence rule. That's what I said a second ago. Let's choose that one, and we got it right. So now let's test ChatGPT and see if it can also get this question correct. Okay, ChatGPT, this is your final chance to get a correct answer here. You've gotten 1 out of 4. Let's see if you can get this final fifth question right. ChatGPT says, it is likely that the trial judge will sustain the defense's objection and require the patient to produce the actual MRI printouts as evidence. Well done, ChatGPT. That is 100% right and for the right reason. So I'm astonished. This is truly impressive. Let's read the rest of its answer and explanation. In a medical malpractice case, the plaintiff has the burden of proving that the defendant healthcare provider breached the applicable standard of care and that this breach caused the plaintiff's injuries. In order to prove these elements, the plaintiff typically must present expert testimony and other evidence such as medical records and test results. In this case, the MRI printouts would likely be considered relevant and material evidence. I would agree with all of that, as they would show the presence of the sponges that were left in the patient's body after the surgery. The patient's testimony about what she observed on the MRI scan would not be sufficient to establish the presence of the sponges without the actual MRI printouts. That's exactly right. Therefore, it is likely that the trial judge would sustain the defense's objection and require the patient to produce the actual MRI printouts as evidence. Again, I am very impressed. This is 100% accurate and correct answer. So ChatGPT, well done. You did not pass the bar exam, but you almost did. It got 2 out of 5 questions answered correctly and gave the right reasoning, legal reasoning behind its answers on those questions. Real Lawyer got, I believe, 4 of our 5 questions correct. And so obviously I would have passed at least the multi-state portion if you extrapolate that out over 200 questions. But this is impressive. And I would not be surprised to see ChatGPT, if it continues to practice and learn on corpus, on legal documents and case law, if they continue to feed that into the algorithm, the artificial intelligence will get to a point probably pretty soon where it can in fact pass the bar exam. This is close to being to a level where it could pass the bar exam. And it's just truly astonishing that you can take 7 years plus 10 years of practice experience and condense that into a single algorithm that can do almost as well as a real lawyer. I mean, watch out, lawyers. This thing is coming for our jobs soon. It's not there yet, but don't be surprised to see it get to the level of passing the bar exam, getting that Juris Doctor degree within the next 2 years at the most. So anyways, that's all I've got for you today. If you want to see more videos like this, where I am having ChatGPT perform legal tasks that I do in my daily job as a lawyer, let me know in the comment section. And don't forget to hit that subscribe button below and turn the bell notification icon on so that you do not miss any additional videos from Legal Pad Law. And of course, as always, thank you for watching.